Hello friends, Mandar here. I'm back with another video. Today we'll talk about some additional information that USCIS has published regarding the number of cases that they have processed so far until end of June and what we can speculate from that number. We'll also talk about a clarification on I140 for EB2. I made a statement in my previous video based on the information that I got from my viewers. I would like to clarify some things about it. Also, we'll talk about I-693, some more predictions on what's next to come, and some things that are happening in the Congress, in the House specifically. There is some good news for the dreamers, people who have come here as children and who are aged out of their parents' application. So there is a lot of packed content in this video. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. I hope everybody is enjoying their summer. I went out for boating with my daughter and it was a great day. It's very close to my house, so we go very often, and I love spending time the day on the water with such a green environment around. Put down in the comment section below what's your definition of enjoying in summer. Also, I would like to remind you that I have some links in the description of this video that are affiliate links, and if you click on them and purchase any kind of product, the channel will get a little bit of a commission. Also, to remind you, if you want to get in touch with me, email is not the best way because I get inundated with the emails and you know how it goes. My preference is contact me on Patreon site, and I'll leave the link in the description and on the screen. If you contact me on the Patreon, I usually get back to you within 2 to 3 days. That's how long it takes me to get to your message. In the last video, we talked about how USCIS is giving us an assurance regarding processing of all the EB visa numbers this year. So it is a good news. They are making a lot of efforts and there are a lot of rules that they are bending, in my opinion, in order to achieve this target. Now remember, USCIS is under tremendous pressure from the administration to clear the backlog. There has been a lot of pressure put on from the Congress to the USCIS to clear the backlog, and they are making all kinds of efforts and all kinds of things. One thing I would like to start with is the clarification on old I-140, approved I-140 from a previous employer. How and when can you use it? Now typically, if you are in the green card process from a backlog country, it takes many years for you to get the green card because your priority date is not current, especially in the EB2 or EB3 category. So in this case, you end up waiting for a very long time, and that puts you into an awkward situation whether to stay with your current employer for years and years or to change. Now USCIS has a provision to be able to change your job after 6 months of waiting on I-485, which is 180 days of waiting on I-485. They allow you to change your job while your pending adjustment of status remains intact. This process is with AC21 rule. Now the problem here is, in my previous video I said people who have downgraded from EB2 to EB3 in the last 2 years, and now with the EB2 moving forward, if the dates are current and if they have already changed a job, whether or not they can use their previous employer's EB2 I-140 that was already approved with your previous employer. In the normal scenario, it is not allowed because there is no job application. Technically, it is not allowed. And here's my reasoning behind it. The entire green card process is based on a job availability by a certain petitioning employer. So an employer is saying that I need this candidate because I cannot find anybody else in the United States. So I want to sponsor this foreign national to work for me. So that's why I'm submitting a petition on his behalf. That's what the premise of employment based application is. Now that is the reason why you cannot use a previously approved I-140 from a different employer, because you have moved on to a different job in a different company, and now that sponsoring employer does not have a job offer for you. So USCIS recognizes that, and they allow you to change your job with AC-21. Now if you want to change the basis of your I-485, can you use your previous employer approved I-140? Technically no. You would have to ask your new employer to apply for your new perm and a new I-140 which is based on EB2 in order to upgrade your petition from EB3 to EB2. Now, but what has been happening lately, and especially in the last 2 or 3 months, is some people are getting away with this, getting away with using the previously approved I-140 from a past employer. Now, USCIS has not updated any policy or any document or anything as such, but they have issued green card on this premise. Even if the person is not working for a company that has issued him an I-140 EB2 based I-140, and if the person has moved on to a new company but he is still waiting on his EB3 process, USCIS has gone ahead in some instance issued him a green card. In some other instances, USCIS has sent a letter to the applicant asking them to submit a letter back to USCIS and requesting them to attach the previously approved I-140 to the pending EB3 485. So that's what has happened. Now if you ask me, this is not written anywhere and this is not a law or anything like that, but this is what we are observing that USCIS is doing, and it is because of the tremendous pressure they are under to use up all these EB visa numbers. So I hope that makes sense. Now let's look at this sponsor video before we move on to our next topic. And that brings me to the sponsor of this video, which is Surfshark. Surfshark is a VPN provider, and that gives you a lot of benefits that you are looking for. Now here is what all Surfshark has to offer. It gives you the power to protect your online privacy, control your personal data, access content safely, and unlock the exclusive benefits of this. What else can it do? You can browse privately, encrypt your internet activity so that no one can steal or track your data, hide your location. This is the key when I was talking about being able to watch the Netflix and Amazon from different countries, block ads and malware, stay safe on public Wi-Fi, keep searches private, and get real search results. And if you are in the tech or IT industry, you know what VPN can provide. Now if you click the link in the description with my code Mandar, you will get a discount, almost 83% discount on VPN deal, and plus 3 months of absolutely free VPN. So check out the link in the description, and if you do get the Surfshark through my discount code, it will also benefit the channel. Now let's quickly talk about the medicals. Medicals is an essential part of the 485 process, and USCIS cannot adjudicate your application unless they have a valid medicals I-693 signed by a doctor. So what they are doing is they are issuing RFEs along with it. So here are my 2 tips. If you are just applying for 485, go ahead and submit the medicals along with your I-485. That way USCIS has it, and they don't need to issue you an RFE for which you need to respond, because that takes a little bit of time. Now just in case if you haven't submitted your medicals along with your I-485, in that case now you should wait until USCIS gives you an RFE notice for medicals to submit the medicals. That is what they are recommending. So in the past I have mentioned that you could go ahead and interfile the medicals to your pending application, but USCIS is coming out and saying no, we will issue you an RFE if we think that we need it, and that's when you respond back to them with a new 693. Now there was a clause in there specifically for the medicals. When you have medicals has to be submitted within 60 days of the signing of the doctor. They also have bended this rule. They have a disclaimer on their I-693 site. The validity period of 60 days within which you need to submit the medicals is no longer applicable. So but if I were you, I would still follow the rule of 60 days, submit the medicals within the 60 days so that they are valid for the next 2 years. So that's just my suggestion. Now here's another thing that I find it interesting. In the last video we reviewed the FAQs submitted by USCIS, and they gave the explanation regarding how many were wasted last year. About 66,000 were wasted last year, but this year they are making a lot of effort to use up all the 280,000 visa numbers for EB category. Just couple of days they had updated this to show how many visa numbers they had used up till May 30th. Now they have updated it to show how many visa numbers they have used until end of June. So through June 30th 2022, the two agencies have combined used 176,000 employment based immigrant visas. We remain committed to take every viable policy and procedural action to maximize our use of available visas by the end of the fiscal year. That's what they are doing. They are taking every policy and procedure into account and see what are the unnecessary steps that they can eliminate that had been there in the past and speed up this operation of issuing the green cards. That's what they are doing. So I have every confidence that they are going to use up all the visa numbers. Now let's see, compare this number 176,000 to end of May number, which was about 149,000. So if you think about it, they processed about 27,000 visa numbers in 30 days. So what does that tell you? They are processing about 1,000 visas, or they are issuing about 1,000 green cards for EB based category in a day. So if you look at it, so since June 30th, so July, August and September, we have 3 months. So 90 days, roughly 90 days or 92 days. So we can expect to see another 90 to 95k visa numbers utilized by USCIS. That is the minimum. So add 90,000 to 176,000, it's already at 166,000, and I think they are going to close that gap between 166 and 180 and 280, and they are going to use up all 280,000 visas by the end of the year. So I'm pretty sure they are going to process another 100,000 visas in July, August and September. So this is a good news, because this is going to ensure that all that backlog of 485s that are pending with the current dates current, that is all going to be used up this year. So in October, we will have the fresh quota of 140,000 visa numbers for EB based category, plus any spillover that come over from the EB category, and I am expecting that to be anywhere between 50 to 70,000 spillovers that will come over again this year. Now the situation is little different this year because the consulates are now open. They are issuing out green cards at the consulates. It's not as bad as last year, so the number might not be as high as like 140,000 that were spilled over last year. It may be a little less. I'm expecting it to be half of that, maybe between 50 to 75,000. So any extra numbers will take it, right? So I would say the next year we'll have about 220 to 225,000 visa numbers available for EB based category. That is just my guess. Now where will the dates land up towards the end of the year, or what will be my prediction for October visa bulletin? We'll find that out in the next month. I'm going to wait for the September visa bulletin to come up to see what the trend is, because we saw they have stopped moving the EB 2 days dates, but they are starting to move the EB 3 dates. So if the trend continues, we want to see that trend in September as well to make some kind of an educated guess what will be the situation in October visa bulletin. Now the last point I wanted to mention is there are some things happening in the Congress. The first thing that I wanted to take you is there is a NDAA bill, it's called the National Defense Authorization Act. That bill was passed by House 2 days back. Now and this was passed with an overwhelming majority of 329 to 101. The reason this is important is because there were some immigration clauses in it. There were a couple of things that I would like to mention here, and if you look at this roll call, nowhere does it mention if it had any immigration clauses in it. I also checked some other such as Politico, and even in this they mentioned that the defense spending bill was passed, but they did not mention if there were any immigration clauses in it. And we know for sure that there were immigration clauses in it because this news from the roll call that there were two things in that bill that were passed. The first one is proposed to help Afghan refugees and documented dreamers were included in the sweeping defense authorization bill that passed the House on Thursday. boosting their likelihood of becoming a law in the midterm election. So all those kids who came here in the United States along with their parents on a valid visa, they have been on their parents' application as a dependent for adjustment of status for a long time. And as per the law, at the age of 21, if they still don't have the green card, they age out. They can no longer be a dependent or mentioned as a dependent on their parents' application. Now this bill will fix that. They will make those documented dreamers along with Afghan refugees to be in the valid status after even after they age out at the age of 21. So they will have a path for permanent residency later on. So that is a very good news, but the problem is this has not passed in the Senate yet. So don't get too excited, because Senate is a whole new different ball game. There is a lot of pushback on any kind of immigration bills or any kind of immigration language to pass through any kind of these bills. So now this NDAA, which is the defense spending bill, that will pass in the Senate as well. But whether or not it will have the same immigration language included in it, that is the question, and that is what we'll look at in the next couple of months. They have to pass this before, I think, end of October, so they still have 2 or 3 months to go, but we will watch this closely. This is the first important step for the documented dreamers, that they will now be able to that this has passed in the House. Now we'll see if it passes in the Senate before it becomes a law. And before I end, I also wanted to show you this poll that I ran regarding, I had posted a question: do you think USCIS will use all available visa numbers for employment based category this year? And I had 4 options. So yes, absolutely, no doubt about it, had 28% of votes. Under 20k of visa vestage had 29%, under 50k had 23%. So people are a little bit skeptical, and best effort is all that matters is 19%. So the majority here is very closely that people think that USCIS is going to use up all the visa numbers for EB category, or if not, they might waste a little bit under 20k. So that was kind of a perception that I got from this voting, and I did also post this on Twitter, and it had similar kind of outcome. So with that said, if you like the video, if you like the content of the video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.